you're stuck with your visa. You have no option out, and your agent or your lawyer tells you, let me apply for a ministerial intervention. Your next step would be to run out of the door. You first run, then you ask the question, do I meet the criteria? Because most of the times, 9 out of 10, the chances you meet the criteria set out for the ministerial intervention is so strict that you are most likely not going to meet it. If you don't know what ministerial intervention is, in simple terms, if you've applied for a visa in Australia, if you're onshore and if your visa is refused, you lodge your appeal for the refusal to the Administrative Reviews Tribunal, to the ART. And if ART refuses, if that application at the ART is refused, you have a right to appeal your case to the minister directly and ask for the minister to use their powers to grant you the visa. But not everyone is eligible to apply for the ministerial intervention. And I'm sure your agent has the best interest in heart for you when they're offering to help you with the ministerial intervention. I'm sure they are competent as well. They have done this previously. But have they done their homework? A, about you. Have they done all the research that they need to do about you? And B, are they updated with the new criteria of ministerial intervention? On 4th of September 2025, the minister introduced a new set of criteria, and almost all of the MI, ministerial intervention is called MI, all of the MI lodged prior to that, almost all, not every MI, but almost all of them got automatic refusals. And they were told to lodge a new ministerial intervention if they meet those certain criteria. So it was a huge drama, huge dilemma in the immigration front about this, which happened in late 2025. So if your agent doesn't know about those criteria, they might get you in a bigger trouble. You already have your visa refused, you already had your ART refusal, you might be waiting your case at the court, at the federal court, you might have applied for another visa. The most important part, if you have applied for another substantive visa and if they suggest you to lodge a ministerial intervention, don't. It will 100% be pushed back. The minister will not get your referral in the first place. You'll get a refusal within a couple of weeks, couple of months. So you'll just be wasting your time. And the worst part is, many times people apply for ministerial intervention when they do not have any other option, when their current visa is about to expire. And which means if your visa is about to expire, you will not get a bridging visa A, B, or C if you've applied for ministerial intervention. You have to go on bridging visa E. And bridging visa E is the worst visas of all. You do not want to go to bridging visa E if you can find other options. Therefore, lodging a ministerial intervention has bad implication that you should be aware of, and your agent should make you aware of this potential bridging visa E. I'll go through some of the criteria which can get the ministerial interventions, and they are: if you are a parent of a minor Australian citizen child, if you are working in a critical occupation, if you are a carer of Australian citizen or permanent resident who have received the medical assessment which is above 30%. So if you are a carer and if no one else can care for that person, there are strict criteria, and there are other criteria as well. And these are the remaining criteria. So you must fall under one of those criteria to be eligible. Otherwise, you can apply for it, but the registrar will look at your application and not even refer it to the minister, straight away refuse it. Minister's interventions are not an easy thing. Not anyone can do it. Not everyone does it. For example, I don't lodge a ministerial intervention, probably not more than 2 in a year, because not everyone will fall under those criteria. And they have specially listed what kind of people are not appropriate to be referred to them. And especially if you've already lodged one MI, and if they have refused it, after the September 2025, if you've lodged one and been refused, no point lodging it again if your scenario hasn't changed. The reason I'm making this particular video is one of my clients who I applied for a parent visa 143, although she is not very old. Her daughter is 22 years old, and she should have been eligible for subclass 494. I told her to go and find an employer in the regional area, but because she was given this false expectation and hope about the MI by another agent, she didn't listen to my advice, went ahead with this, and ultimately she ended up on bridging visa E. And recently, like within 2 months or 2.5 months, her MI got rejected. So I don't want you to fall in such trap. Therefore, do a proper investigation whether or not you are eligible. If not, don't apply for a ministerial intervention. This is not like ART or federal court, which is going to take years. Yes, it will take years for the right ministerial intervention cases, but if you don't meet the criteria, they will refuse it within a month, 2 months, 3 months max. And you must understand, this is the minister exercising their power of individually, personally deciding for those cases which has been refused by the department, by the ART. They are sitting and reading your submission and deciding your case whether you should be granted the visa or not, which means you must be an exceptional case, right? So not everyone gets to apply for it. So do your research thoroughly.